I can assure you that the following is not a trick question. Is there a connection between undersized red grouper and the disgraced company Enron? Well, it turns out that the answer to that question is yes, and that connection came within one vote of landing John Yates in federal prison. So the Yates case began on October 23rd of 2007 when John Jones, a field officer with the Florida Fish and Wildlife Conservation Commission, boarded the Miss Katy, which was a commercial fishing vessel under the control of John Yates and his small crew. Jones, who had been deputized as a federal agent to enforce federal fisheries laws, spotted 3 red grouper that appeared to him to be undersized and proceeded to spend the next several hours inspecting all of the fish in the Miss Katy's hold. That was over 3,000 fish. He ultimately concluded that there were 72 undersized grouper that measure between 18 3/4 inches and 19 3/4 inches, which was below the 20-inch limit. Ironically, by the way, the rules with respect to undersized grouper have now been changed, and the new limit is 18 inches. So if Yates had been inspected actually on the day he was indicted, and certainly if he'd been inspected today, all of his fish would have been in the clear, but that's a story for another day. Now, harvesting undersized grouper is not a crime, but it is a civil infraction that can subject you to a $500 fine and can possibly get your fishing license suspended. Jones ordered Yates to put those 72 fish into a separate wooden crate, but he neglected to seal the crate. And he told Yates to leave them there until the Miss Katy returned to port. Once the ship returned to port a few days later, Jones inspected the fish again and discovered, much to his horror, that now there were only 69 fish that were undersized, and they appeared to be much closer to the 20-inch limit than the fish he had inspected at sea. Well, being a crackerjack federal investigator, Jones eventually got one of the crew members to admit that Yates had ordered him to throw the original 72 fish overboard and to replace them with other fish. Well, that simply couldn't be tolerated. So what was the government going to do in response to this perfidy? Well, naturally, a federal prosecutor ended up charging Yates with 3 felony counts. The first charge was a violation of 18 U.S.C. Section 1001. It carries a potential penalty of 5 years, and that was for lying to a federal officer by falsely stating that the fish that Jones had inspected on the dock were the same fish that he had inspected at sea. The second charge, a violation of 18 U.S.C. Section 2232, also carries a potential 5-year penalty, and that was for throwing the grouper overboard in order to prevent the government from taking possession of them. So it's a form of an obstruction of justice statute. The third charge was 18 U.S.C. Section 1519. That is known as the Sarbanes-Oxley anti-shredding provision. And that carried a potential penalty of 20 years for destroying, concealing, and covering up the undersized grouper with the intent to impede, obstruct, and influence the investigation and proper administration of fishing regulations. Now, the Sarbanes-Oxley anti-shredding provision had been enacted in the wake of the Enron fiasco when it was discovered that Arthur Andersen employees had spent approximately 2.5 weeks engaging in an infamous shredding party, destroying Enron documents, email systems, hard drives, whatever they could get their hands on to cover up Enron's misdeeds in anticipation of a government investigation. Shredding party stopped the moment a subpoena was issued. And one of the problems that emerged during the Arthur Andersen trial, in fact, was the fact that existing obstruction of justice laws did not cover the destruction, alteration, or fabrication of documents prior to the initiation of an investigation. And another problem that came to light is that existing obstruction of justice laws made it a crime to persuade others to destroy evidence, but not to destroy evidence yourself. So Congress ended up passing a law making it a crime, again subject to a potential 20-year penalty, to knowingly alter, destroy, mutilate, conceal, cover up, falsify, or make a false entry in any record, document, or tangible object with the intent to impede, obstruct, or influence the investigation or proper administration of any matter within the jurisdiction of any department or agency of the United States or in contemplation thereof. So, of course, a fish is a tangible object. So quite naturally, the feds decided to charge John Yates with violating this statute, effectively turning what had been a civil infraction into a potential 20-year felony. And John Yates went to trial, and he was acquitted of the false statement charge, but he was convicted of the 2 obstruction of justice charges. The guideline range called for a sentence between 21 and 27 months, and John Yates was sentenced to 30 days in prison. After his conviction, Yates sought certiorari, challenging his conviction under the 20-year obstruction statute, but not under the 5-year obstruction statute. And the court decided to hear the case. But I think it can fairly be asked, why? After all, Yates was only challenging his conviction. He wasn't challenging his conviction under the 5-year statute. And he had received a sentence that was well below both the statutory maximum and the guideline range. And of course, it was highly unlikely that this bizarre fact pattern was going to result in somebody being charged in the future for something similar. I think the answer to why the court decided to hear this case has a lot to do with fear of governmental overreaching in the area of criminal law and a concern that overly aggressive interpretations of federal law can give the government an unfair leverage in plea negotiations and can also be unfair in terms of providing adequate notice to average citizens about when their conduct crosses the line and becomes a crime. John Yates prevailed before the United States Supreme Court, but barely. Justice Ginsburg wrote the plurality opinion that was joined by the Chief Justice and Justices Breyer and Sotomayor, and Justice Alito wrote a separate concurring opinion providing the critical 5th vote for Yates. Those 5 justices placed their reliance on 2 rules of statutory construction, a nocitur associus and a justum generis. The former instructs that when words grouped in a list should be given a related meaning to each other, and the latter instructs that when vague words in a statute are followed by specific words, the general words should be construed to embrace only objects that are similar in nature to those objects that were delineated through specific words. In this case, the plurality and the concurrence concluded that the term tangible object in a statute with such company as record and document made it highly unlikely that Congress meant for that term to apply to fish. They also said that it is very hard to envision, while one can certainly destroy, mutilate, conceal, or cover up a fish, it is very hard to envision falsifying or making a false entry into a fish. They also said that they considered it highly unlikely that Congress would pass a 20-year obstruction of justice statute that would completely subsume the 5-year obstruction of justice statute that Yates had also been charged with. And they therefore decided to give a limiting construction to the term tangible object in the anti-shredding provision. And the plurality was prepared to even go further and say, if necessary, the rule of lenity ought to apply, and the tie would go to Yates. Now, the dissent by Justice Kagan, which was joined by Justices Scalia, Thomas, and Kennedy, they were having none of it. To her, a tangible object is an object that is tangible in all of its applications, and that would include a fish. Now, that's a bit difficult to take from a justice who was not prepared to rely on the seeming lack of ambiguity when considering the statutory phrase established by the state, or the constitutional phrase in the Arizona legislature, shall be prescribed in each state by the legislature thereof. But there you are. She did not believe that the statute contained an ambiguity and chided the other justices for reading the statute in such a way as to create an ambiguity. That's another view that was a bit tough to take from her. Now, Justice Kagan believes that she knows the real reason why the plurality and the concurrence, Justice Alito, voted to overturn Yates's conviction. She said, quote, it was overcriminalization and excessive punishment in the U.S. Code. And while the dissenters would have affirmed Yates's conviction, Justice Kagan readily acknowledged that the anti-shredding provision is, quote, is a bad law, too broad and undifferentiated, with too high maximum penalties, which give prosecutors too much leverage and sentencers too much discretion. Moreover, she stated that this statute was unfortunately not an outlier, but an emblem of a deeper pathology in the federal criminal code. I think she's on to something. During the oral argument, several of the justices expressed great concern about prosecutorial overreaching. Justice Scalia wondered aloud whether the prosecutor in the Yates case was indeed the same person who had prosecuted Carol Ann Bond. As Ilya told you, that was a case from a couple of terms ago in which a woman tried to do in or harm, ended up causing trivial harm, a finger burn, to her former best friend who had an affair and become impregnated by Bond's husband, and she ended up being prosecuted under, you guessed it, the Chemical Weapons Implementation Act, which most people thought had been reserved for terrorists who would use chemical, biological, and neurological weapons against an unsuspecting public, such as the doomsday cult Aum Shinrikyo, which in 1995 let loose sarin gas on the Tokyo subway system. Justice Scalia was not pleased during oral argument to hear that the customary practice of federal prosecutors is to charge, quote, the most serious offense that is consistent with the nature of the defendant's conduct and that is likely to result in a sustainable conviction. When the government's lawyer stated that the government does not prosecute, of course, every fish disposal case, Chief Justice Roberts was very quick to retort. But the point is that you could, and that once you can, every time you get somebody who is throwing fish overboard, you can go to him and say, look, if we prosecute you, you're facing 20 years. So why don't you plead down to 1 year or something like that? It's an extraordinary leverage that the broadest interpretation of this statute would give federal prosecutors. Precisely so. In my view, the Yates case should be read along with not only the Bond case from a couple of terms ago, but from a couple of other cases this term. The Alanis case, which was the True Threats case, the McFadden case, which was the drug analog case, and I suppose you could also add the Johnson case, which dealt with the residual clause of the Armed Career Criminal Act. These cases, I believe, stand generally for the proposition that the emphasis in criminal cases must remain on the intent of the accused, even when he engages in conduct that appears objectively unreasonable, and that the court will not allow the government to stretch too far in how aggressively it interprets the reach of criminal statutes, especially when your average citizen could not reasonably have anticipated that such an interpretation would encompass what most of us would view as pretty benign conduct.